I'm Spencer Bishop, and I'm speaking on behalf of the Fourth Amendment and the protection it gives digital files from unreasonable searches and seizures. But what does it mean to unreasonably search or seize someone's digital files? As it turns out, this question isn't just lacking a clear answer, but it's also vital for determining nearly every case involving digital evidence in an investigation. Oren Kerr in the Yale Law Journal describes physical examples of searches and seizures in broad, understandable terms. When the government invades a private space, violating a reasonable expectation of privacy, that invasion constitutes a search. And when the government then spots evidence or contraband and takes it away for use in a trial, that physical taking of the evidence amounts as a seizure. The same principles applied to digital data is not as straightforward. Is copying data onto a hard drive searching personal files, even if these files aren't observed? What about the seizure of the computers themselves and the data on the hard drive that is taken? In two court cases, Arizona v. Hicks, where a stolen stereo was identified by its serial number, and Bill v. Estelline, where photographs of guns and marijuana plants were used as evidence in court, it was ruled that copies made of physical objects, the serial number from the stereo, and the photographs taken of contraband did not constitute seizure, citing, in their words, how the copies did not meaningfully interfere with any possessory interests. However, in the case United States v. Jefferson, piles of documents photographed outside of the scope of the warrant that was issued were ruled as seized, presumably due to the existing nature of documents as copies of another digital file. These court cases serve as a distinction between unique physical property and the easily copied digital property with no distinction between original and clone. Another instance of unlawful searches and seizures involves a computer repair technician working on a customer's computer with a faulty hard drive. The technician needed to copy the files over to a newer device, and in doing so, they uncovered illegal files and alerted the police, who wrongly seized the files without a warrant. This was unreasonable because the computer technician had no justification to search through the individual files on the computer without informing the customer of what his service entailed, and even less of a right to allow the police to seize the files at hand. This case, titled Commonwealth v. Schaffer, follows the same principle of copied files, as the duplicate files from the original hard drive should still require a warrant to be searched. Beyond this case study, there are more commonplace searches of people without warrants that happen every day. Common practice at our own borders include routine inspections of people entering the country, and this is permitted by the Supreme Court. These inspections allow relatively limited manual searches of phones and computers, but there's no line drawn as to how intrusive the Border Patrol may be without having heightened suspicion to justify a warrant. The only written laws included on what surpasses a routine search have nothing to do with digital media. The court has listed strip, body cavity, or involuntary x-ray searches as falling outside of this category of routine search, and more vague rulings of not breaching personal dignity or privacy interests are also too vague to constitute what files are off limits on a computer or which emails are even fair game. In Alizad v. Mayorkas, 11 lawful U.S. residents returning to the country were detained for an extended period and coerced into unlocking their cell phones, revealing private information. When these 11 people thought that their Fourth Amendment rights were violated, the court ruled that a search of one's phone is not an intrusive search of a person, and thus is subject to a routine border inspection. The court did concede that advanced searches of electronics violates the Fourth Amendment, but the obscurity of what an advanced search encompasses, that a routine search does not give a Border Patrol guards the power to hold innocent people for far longer than they should ever be held. In instances like this, it's clear we need more regulation to keep up with the changing world that we're in. Daniel Zwerdling from NPR wrote, "The government often doesn't have many legal restraints. America's founders were not thinking about computers when they wrote the Bill of Rights. Because of this, many of the important rulings that have been that have been made in recent decades are based on our best interpretation of the absolute constitutional amendments that we follow. These interpretations are often taken advantage of. For instance, the government can obtain our personal data without our knowledge by going straight to a company that holds our information with subpoenas and asking them for phone records, location data, and even our electricity bills, just because it's information we're required to share in the first place. Golden Valley Electric Co., an electric company that dealt with this very situation, even attempted to block a subpoena like this in court to preserve the privacy of its customers. The information, once collected by the DEA searching for anyone growing drugs in their home, could be used to justify kicking down the door of an innocent kid with too much free time and too many Bitcoin mines. For decades, the most common exceptions to the Fourth Amendment, such as criminal activity in the plain view of a law enforcement officer, have become precedents whenever similar cases occur. But what does criminal activity in plain view mean when it comes to the digital information that we share every day? So many of our old court rulings are tried on modern cases that we quickly begin to oversimplify complex cases in order to preserve an outdated standard. The Fourth Amendment itself begins with the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. As only 2 words to encompass everything that has changed about our world in the last 250 years. And effects. The effects of this and effects is evident in every court case I've mentioned, from the seizure of someone's computer hard drive to the unreasonable search of a neighborhood's electric bills. I hope that one day we can see the actual effects of our changing future on an ancient past.